Good evening. I'm Angela Jameson, Chair of New Canaan's Inland Wetland Commission. I'm calling to order the meeting of the Inland Wetlands Commission on Monday, April the 7th, 2025 at 7:03 p.m. Please would the Secretary call the roll?
Angela Jameson, Chairman. Sandy Redden, Secretary, here. Beth Bernali, I believe, is reclusing herself.
Yes.
She's absent.
Beth Samford.
Here.
Daniel Stepanek.
Here.
Philip Williams.
Here.
Priscilla Wolke, I believe, is absent. Don Mastronardi, absent. Katie Owsley.
Here.
Adam Ramirez.
Here.
Thank you.
Thank you. So Commissioner Ramirez, please would you take the place of Commissioner Brunali?
Yes.
And thank you. And Commissioner Owsley, please would you take the place of Commissioner Woike?
Yes.
Thank you. So first item of business is to approve the agenda for this evening's meeting. Does anyone have any questions or comments? If not, please could I hear a motion to approve?
I make a motion to approve the agenda for tonight's meeting.
Thank you, Commissioner Ramirez.
I second it.
Secretary Redden, thank you. All those in favor, please raise your hand. Aye.
Aye.
So that is passed unanimously. Then we have the minutes of the special meeting of March 24th, 2025. Please could I hear if there are any comments or revisions? And if not, a motion to approve.
I make a motion to approve the minutes of March 24th.
Thank you.
That's Sanford.
Very good. All those in favor, please raise your hand.
Angela, this is Dan. I wasn't at that meeting, but I did review the video and all the documents connected with that meeting, you know.
Very good, thank you. So now we will continue the public hearing. I'm sorry, I beg your pardon. We will open the regular meeting and review have a look at the applications that have been received. The first one is IW 25-10, 676 Laurel Road. A. Hallen, to excavate a pond within the existing stream channel and associated wetland area, create a plunge pool to capture sediment before it enters the pond. And then the second application is IW-25-11, 42 Riverbank Court, John Douglas. Legalized minor cosmetic stonework recently installed on existing stone walls and structures along 5 Mile River. Proposal also includes installing plantings and minor landscaping around the stone structure and along the stream for stabilization. So we need to schedule a site visit to take a look at those two sites. And we're proposing May 7th, starting at 7:30 a.m. Let's go around the table and see who can make that. I know I can't, but I'm sure others will be able to.
We also, because our meeting is early this month, we could also look at April 30th, which would be the Wednesday before,
Yeah,
if that was more conducive to the majority of
Right.
the commission members.
well, let's just have a show of hands for all those that can make April 30th. That's 3, 4, 5. Dan,
He said yes already. He had- I had mentioned to him.
6. Adam, can you make it?
Hold on. Yes.
Okay, so it looks like everybody can make April 30th. What about May 7th?
Yes.
I
Yes.
can't.
Unsure.
Okay.
Yeah, that's-
Beth,
Yeah, it's good.
Dan, May
He-
7th?
He was back in town.
Yep.
He's muted.
So there are two people who can't make it on May 7th. Everybody could make it on April 30th. So let's shoot for April 30th. And we're starting at 7:30 to accommodate the schedules of those who have day jobs. And because it's also lighter in the mornings. Very good. So now we can continue the public hearing. Application IW-24-43, 82 Brookwood Lane, Brookwood Hills LLC. The proposed regulated activity for which an inland wetland permit is being sought is the construction of common infrastructure to support a proposed 9-lot residential subdivision. The regulated infrastructure activities include the conversion and expansion of a single-lane asphalt driveway, the installation of associated stormwater best management practices, the installation of power communication and data utility lines, the installation of a dry hydrant, and the completion of wetland and watercourse mitigation activities. Permits are not being sought for the development of each lot. So this is our sole item of business this evening, and here's our plan for proceeding. First off, we're going to hear from the town attorney on the process that we will be following. I will then invite the interveners to present any new material that they have submitted since the last meeting. We'll then see if there are any additional comments from the general public, and then we'll give the applicant the chance to present their concluding remarks. At that point, we may actually be in a situation where we can close the public hearing and start deliberating as a commission. We may even be able to get to a vote on the application, as well as the vote on the pleading by the interveners. So before we get going, I would just like to ask each of the commissioners to attest to two things. One, that they either attended all 3 meetings that we've had so far on this application, or looked at the video for any meetings that they missed. And then also to attest that they have reviewed all the material on the record on the website. So maybe we can just go down the line here, starting with Commissioner Williams.
Yes, I can attest that I did all of that.
Thank you. Commissioner Sanford,
Yes, I was at all 3 meetings and have read the materials online.
Commissioner Redden.
Yes, I attended all the meetings, site visits twice, and have been through all the materials.
Thank you. Angela Jameson, I can attest to both. Commissioner Ramirez,
Yes, I attended all the meetings and reviewed the materials.
Commissioner Owsley.
Yes, I can attest to both.
Thank you. Commissioner Stepanek.
I attended 2 of the meetings and watched the video of one of them, and I've read and all the other material based on what I missed at the March 24th meeting.
Thank you so much. So we are holding a public hearing because we received a verified petition, and we do not therefore have to consider whether the proposal may have a significant impact on the wetlands and water courses. In a minute, the town attorney, Gelderman, is going to just talk us through why this is the case and the process that we should follow when we're making a decision. And then secondly, he'll also address the process that we should follow in making a decision about the special, the pleading of the interveners that asserts that the application involves conduct which has or which is reasonably likely to have the effect of unreasonably polluting, impairing, or destroying the public trust in the air, water, or other natural resources of the state. So, Attorney Gelderman, the floor is yours. I think you're on mute.
There we go. I was waiting for the host to unmute me there. You can all hear me now, I assume?
Yes.
Yes.
Thank you.
Great. So let's start with the first issue that Angela brought up, and that is and I think there was a little bit of confusion about this. As most of the commission or all of the commissioners know, generally speaking, wetland matters do not get heard in a public hearing unless one of three things happens. One is that there is a petition. Another is that the commission determines that a public hearing would be in the public interest. And the third is, and this is where the confusion is, if the commission finds that the proposed activity may have an adverse impact on wetlands and watercourses. So the may have an impact only comes into play if the commission is considering holding a public hearing. Because there's been yet no substantial evidence. So you look at the application, and if you think it may have an impact, you haven't found that it will have an impact, but if it may, then you can hold a public hearing. In this case, you're holding a public hearing because there was a petition filed. So you didn't have to consider whether the activity may have an impact. So you hold a public hearing. Now your obligation is to determine if it's likely that the proposed activity will have an adverse impact on wetlands or watercourses. The same standard you use in any review of an application that comes before you. You're listening to the substantial evidence, which is the expert testimony of the people who have testified and presented reports and opinions to you, and you're going to make a determination whether it is likely that that activity will have an adverse impact on wetlands and watercourses. If you find that there is a likely negative adverse impact on wetlands and watercourses, then typically you would ask the applicant if they can come up with any feasible and prudent alternatives to the application that was submitted. And if the applicant can do that, then that feasible and prudent alternative would be considered. The application would have to be denied if there is a feasible and prudent alternative. But you only get to a feasible and prudent alternative if the proposed activity is likely to have an adverse impact on wetlands and watercourses. So that's the first thing when the public hearing is closed and you're considering, that's the primary thing that you're going to consider as to whether or not this activity is likely to have an adverse impact. So just to summarize, you don't have to, this is not a question of may, that's a possible impact. This is a question of likely, which is a probable impact. And that impact has to be identifiable. If there has to be substantial evidence in the record of what that impact is or will be. It's not just speculation, it's actual what that impact is going to be on the wetland or watercourse. So that, I think that hopefully answers that question. With respect to this particular application, it's being referred to really on two levels. The first is the application itself to conduct a regulated activity. That's the driveway, the common driveway that was spoken about by in the heading when you read in the item. The other reason that it's before you is because it involves a subdivision. Anytime a subdivision has wetlands within the boundary of the subdivision, an applicant is required to submit an application to the Inland Wetland Agency, and the Inland Wetland Agency will render a report to the Planning and Zoning Commission, which the Planning and Zoning Commission is obligated to consider before it makes its decision on the subdivision. So that simply means that even if an item is not a specific regulated activity, the commission can still comment and make recommendations to the Planning and Zoning Commission if it so chooses. In the context of the subdivision, there's no requirement that an applicant has to submit specific site development plans for the individual lots that are part of the subdivision. That's not a requirement. The commission can certainly consider that there will be houses, presumably, on those lots. But the reason you don't really get into the specific site development plans at this point in time is because since they haven't been submitted, you don't know what impacts those houses are going to have on the wetlands and watercourses. There could be mitigation, there could be swales, there could be different kinds of drainage plans submitted. So you have no idea what the impact of those individual houses, if any, what that impact is going to be on wetlands and watercourses. So that's why, generally speaking, when the individual lots are being developed, there'll be a separate review for those individual lots. But today you're reviewing the proposed regulated activity and making a determination whether it is likely to have a adverse impact on wetlands and watercourses, and you're then going to make a report also to the Planning and Zoning Commission. Finally, you have interveners in this matter, so you will make a separate determination as to whether the interveners, through substantial evidence, meaning expert testimony or documentation, have met their burden of showing that the activity is reasonably likely to have unreasonably pollute the air, waters, resources of the state of Connecticut. So that's a separate resolution that you'll determine after you've made your determination on presumably on whether or not this activity should be permitted or not. So those are the things that you're considering tonight, and I'll be here if anybody has any questions or from me during the course of the hearing or during the deliberation if you get to that point tonight.
Thank you, Attorney Gelderman. Do any commission members have any questions right now for the town attorney? Commissioner Sanford.
Thank you. That was very clear. Though I do have a question. So what you said at the very end, which is that we're evaluating the proposed regulated activity that the applicant has laid out as one, evaluation. The second is that we have to determine if the intervener has proved their case, and that is a separate resolution. The two have to be consistent between them.
I would think they would be, yes. They typically are. So if, for example, just hypothetically, if the commission made a determination that there was no adverse impact, then the commission would adopt a resolution that would indicate that the interveners have not met their burden.
Thank you.
So thank you for that clarification. Any more questions from the commission for Attorney Gelderman? If not, we'll turn the floor over to the interveners. Yes, please.
Mr. Freeman, good evening. Can you just make sure you hit that button there until the green light comes on? And I believe this is Mr. Grimes joining you. You have to get it to go green. There you go.
I'm Rob Freeman, Spencer Grimes. I've met you previously on a Zoom. Our attorney, Adam Blank, is not available tonight. So we're hoping that we can address some of the questions that we have. We've consulted with him extensively. You've obviously seen his memos, as you all attested to. So we're not, gonna go through all that, but we do have some points that we wanted to touch on, given that this is, I think our last opportunity to do so. We also made the decision that SE Minor did not need to be here tonight because, frankly, we've said what we have to say. We've submitted a lot of materials to all of you. Obviously, the applicant has also submitted extensive materials to you, including a letter this morning that we've not had a chance to respond to, and that is part of what we would like to have the opportunity at this hearing to briefly discuss. So I'll pause and ask you if that's okay and if that fits with your agenda.
Certainly. I mean, this it would be the last opportunity for you to present any additional information that isn't already in the record. I think we're all very familiar with what has been presented up to this point by the interveners and their experts. So no need to repeat all that, but just anything additionally.
And that's what I'm going to try to do.
Very good.
Our points that we're going to make are consistent. We're not bringing up new points because anything new would have been presented, by our advisors. But there are a couple of I'll call it color commentary elements that we would like to make, including related to the comments that Attorney Town Council Gelderman just made, and again based on our discussions with our own council. I do want to point out, and I don't know how many of our neighbors are on the Zoom, but there are a number, we think, and I don't know, Kathleen. We've been getting texts from people who are saying they're having a hard time getting in, so I'm not sure.
I don't know why that would be. I've got 16 people, most of which are the computers up here connected. So I have a few names, but I can't tell if they're neighbors or not.
But we'll see. I mean, my wife is at home and she was texting me that she was having trouble. So in any case, we'll proceed. Three subjects that I'd like to touch on. First is the significant impact discussion. Second is inevitable development, and third is alternatives. As Attorney Adam Blank has written in his memos, candidly, we just don't agree with the town attorney's interpretation of the regulations and of Connecticut case law, that this public hearing eliminates the need to consider whether the proposal may have a significant impact on the wetlands. We have an entirely different point of view from a legal perspective. In the applicant's prior filings, they argued strenuously to avoid a significant impact designation, which, as I think everybody knows, would require the applicant to do more costly and time-consuming work on all the feasible and prudent alternatives, including that of building fewer homes on the site. At least two of the letters from the Rucci law firm, the February 24th letter and the March 24th letter, address the significant impact designation in depth, as did our council's filings with you. In neither of those letters, nor in the public hearings where Ms. Zabatakis had the opportunity to present those findings, in neither of those did the applicant's counsel suggest that the reason the IWC did not need to consider significant impact was because of the public hearing. That it never came up. I understand that, and I heard it with my own ears, that Attorney Gelderman has advised otherwise, but I do want to make sure you understand that we have a very different point of view and we have case law. In addition, you'll recall that at the February 24th hearing, at the end of the meeting, there was a discussion among the commissioners and the staff about conducting a vote on significant impact. In the transcript of that meeting, at least 2 commissioners indicated that they feel there, quote, may be a significant impact of the shared driveway on the wetlands. Ultimately, you'll recall that discussion was tabled until the following meeting to provide the commissioners and the staff more time to review the specific language and the 7 key provisions and to consult with counsel. In our view, without further discussion and a vote on significant impact, which we understand you're not inclined or not going to do, the legal concept that this public hearing negates the need for a wetlands commission, the need for the Wetlands Commission to consider whether the application may have a significant impact is not, in our judgment, a supportable agreement in an appeal. Second point, with regard to our request that we made and we've been consistently making, that the typical 2-step process be combined into a single step so that the commission can evaluate the impact of future home development. It seems that there's a reliance on the March 21st memo from Mr. Gelderman to the commission dealing with the difference between the concept of adverse impact and impact. And again, I just heard Mr. Gelderman speak to that. We can't find reference to that in the regulations. We see, and our counsel has provided information from section 12.2, paragraph 7, that states that the commission, quote, shall take into consideration the impact of the wetlands, of the proposed activity and future activities associated with or reasonably related to the proposed activity, which are made inevitable by the activity and which may have an impact. The words adverse impact don't come up as far as we can see. We have filed, as you know, supporting material to that from both Adam Blank at Wolfsey Rosen and from S.E. Minor. So our view is that the regulation specifies impact, not adverse impact. And we have not seen any documentation, perhaps you've been advised separately by counsel, that the concept of the future inevitable activity on the site is not pertinent. In our view, as we've talked about extensively, we think it is. The entire application of the applicant is predicated on the development of numerous homes in this subdivision. And in fact, at the last meeting, the special meeting that took place a couple of weeks ago, Ms. Zabatakis stated that, quote, there is no wetlands impact from sites 1 through 4 of this application. We agree with that. That's a factual statement. But our filings and those of the applicant, all of the filings have indicated that there is wetlands present throughout the site. And in fact, it touches on all 9 proposed lots. So from our perspective, it is inevitable that any combination of future home building applications may have an impact on the wetlands present, even if, as has been cited, somebody buys 2 lots or 3 lots. All 9 lots, as presently configured, have wetlands. So it is inevitable that building a home on anywhere on that site is going to have impact from the wetlands. Third, as requested by the commission at the last meeting, we've submitted not 1, but 2 separate alternatives, and I know you've seen them, you referenced it in the beginning of the meeting. As discussed in response to, I believe it was Commissioner Redden's question on February 24th at the meeting that I previously had the chance to speak to you at. And we've referenced this, frankly, in our advisors' comments at this in the room and in their filings. We are not opposed to development. And we've been very clear about that from the beginning. This is not a, what do you call it, a NIMBY, kind of thing. The alternatives that we've proposed, there are 2 of them. One is by S.E. Minor, that's for 7 homes. There's another one by a professional landscape architect, Lindsay Byrne. That one's for 6 homes. Very similar proposals if you've had a chance to look at them. And I'll note that that's more than the 5 homes that I referenced when I spoke on February 24th. So the professionals have set forth 2 viable alternatives. Both of those proposals eliminate the shared driveway and the wetlands impact of almost entirely and result in fewer trees being removed. The letter from the applicants this morning criticizes these alternatives for not providing more detail on the wetlands remediation and restoration and the fire protection elements of the pond. And I just want to say, of course, we expect any alternative plans to include the wetlands remediation and restoration and the fire protection, because it's been put on the record that that's part of the proposal. Our view is that the burden is on the applicant to detail for the commission how they will do that in any alternative plan. It's our understanding that's what the regulation says and that that's what the case law says. So our presentation of two alternatives is simply to prove, one, that we're serious in our desire to right-size this development, not to eliminate the development, just to right-size it. And second, to refute the applicant's written contention that there are no feasible and prudent alternatives. They've made that point numerous times, bold letters, underlined, capital. There are, and we've presented them to you. We didn't have the tools, the CAD resources, and the money, frankly, to do the same kind of detail, soil science and all that. But we took their plans, and we came up with a way to get rid of the shared driveway, which is what the applicant is seeking approval for. And we want you to understand that we think that that is a viable alternative. Finally, one last point. The applicant's letter to the commission today makes, frankly, an untrue allegation about me and about Spencer and about our neighbors. And it's offensive, frankly. They claim that we have, quote, a pattern of opposition based on the falsehood that when Richard Gere submitted an application for a permit for agricultural use on that property when he owned it, that we opposed it. This is absolutely false. Spencer and I and numerous other neighbors attended that hearing, and as is our right to do. And we asked some questions of the project of attorney David Rucci, who was representing Mr. Gere, and Mr. Gere, who was here. We raised no objections. We filed no petitions. We were not interveners. Frankly, we love the idea of them growing mushrooms and flowers and grazing goats on their property. We also appreciated that at that meeting when we pointed out to Mr. Gere that there was a wooden fence that he had installed that impacted the traffic sight lines around a corner, that within a week or two they removed it. It was a normal, from my perspective, having not been through this process before, it was a normal case of neighbors using their rights to speak to a town commission. So we can agree to disagree with the developers about the law and the regulations. Obviously, we do disagree, but frankly, I feel there's no place in this hearing process for stating personal falsehoods about the interveners. We're simply concerned and active citizens exercising our voice. Thank you very much.
Thank you very much indeed, Mr. Freeman.
Yes.
Did Mr. Grimes wish to speak?
I don't think so. I think we may have a couple of other neighbors though.
So let's see if commission members have, you have other.
I'm not sure.
So my understanding is that the two interveners are Mr. Freeman and Mr. Grimes, and you've had your credentialed experts who've provided presentations but aren't here this evening. So we will get to members of the public very shortly. But before we do that, let's see if there are questions from commission members for the two interveners, Mr. Freeman and Mr. Grimes.
And Commissioner, if I may, or Chairman Jameson, the one thing I do want to point out is one of our plans, alternative plans, is by Lindsay Byrne, and I believe she is on the line. Is that right? So if you have questions, she is a licensed professional landscape architect. So if you have questions about Lindsay Byrne, designer. So if you have questions about what that plan, she's available to respond to that.
Thank
Sorry
you.
for interrupting.
So do we have questions for the two interveners?
Angela, this is Dan.
Yes, please go ahead.
This is Dan Stepanek. I'm not quite clear what issues you looked at to reduce the number of houses from 7 or 6. How can you be in more detail on that? Give us more detail on that.
Sure. And, you know, the site plans tell, you know, a picture tells 1,000 words. So what our site plan, both of those site plans do is they eliminate the shared driveway. Again, that's what the applicant is seeking approval for. So it's fundamental to the project. And they have the access to the lots that are on the western side of Brookwood Lane, the top of the site map, if you think about it that way. The access to the excuse me, to those homes would be from Brookwood Lane. There has been extensive discussion about the public access way and the fact that that's a wooded area, which of course it is. 91 trees would need to be removed. I think that was the number that Mr. Kenny or Mr. DeAndrea had pointed out. What both plans, alternative plans, show is that rather than clear cutting those trees, simply run a shared driveway just below the public access way and drop down to the two homes. So, and you know, candidly, this is not the most favorable outcome for my own home. I'm at the top on the western side, or for Spencer, or for you know, for some of the other people here. However, it is a viable, feasible, prudent alternative that eliminates the damage to the wetlands that would be impacted by the shared driveway. So, Mr. Stepanek, that's the best I can answer the question without using the map. I don't have a computer with me and so forth, but I do have copies of the plans, but I believe you all do as well.
We do. We're looking at them right now. Thank you.
They are based on the same drawing. We essentially, Ms. Byrne took the plan that S.E. Minor prepared and then made some additional, you know, changes to it. The other benefit of it, of course, and consistent with the request of the land trust, which I know has been in touch in writing, and also the New Canaan Conservation Committee, is that by doing this, you have a contiguous open space on the eastern side of the property where the wetlands are. And that's one of the stated goals.
Just want to clarify, no communications have come from Land Trust to the Inland Mountains Commission. So I think we're getting the commissions confused. I believe everything's been submitted to planning.
To P&C. I apologize.
And can I just clarify? So this this sketch that was done on did you indicate that Lindsay Burns actually did the layout? Not S.E.
Not the
Minor?
one that's in your hand.
Okay,
That's S.E. Minor's work, and their logo is on the bottom of it. The bottom right-hand corner, it says S.E. Minor.
Okay, so this was done by.
This is work of S.E. Minor, and they submitted a fairly extensive memo describing why they did this. What Lindsay did was she took that and then made some alterations to it and submitted it in a separate letter that's in the file. I know that.
I got it. Okay, I just wanted to clarify because I don't think a landscape designer can do roadway design things. So I just wanted to make sure. So S.E. Minor had done that plan.
They did all of that, and then she, you know, she essentially took out one of their house. Really,
I understand. Thank you.
Sure. Commissioner Stepanek, does that answer your question? Do you have any follow-up?
Well, can I do a follow-up question here?
Sure.
I know we're going to, on phase 2, we're planning on looking at each individual lot, okay? Have you gone as far to decide which lots you would eliminate?
yes, yes, sir. And on the plan, it does show that on each of the two plans, it does show which lots would be eliminated.
If I may just ask a supplementary question here. I don't believe that you provided any reasons on the record for why you're eliminating the number of lots.
Consultants.
Essentially to eliminate the shared driveway. I mean, that's the reason.
But I don't think we've had anything from your credentialed experts on that point.
I believe
as far as that wetlands impact is concerned.
No, I understand, and I take the point earlier. I'm at a loss, but I believe that that they did submit a memo on Friday. I think actually somebody came to the office here to submit that with the alternative plan. If none of you have it, then that means it didn't happen. I understand that, but I've certainly seen it.
We do have documentation from SE Minor. It's not to the level of detail. I think that's what is missing. So
I think that's a judgment that you'll have to decide on. I mean, again, I'm at a loss because we're under the impression that it was. And we've been to now 4 or 5 hearings. And at each of the hearings, the discussion has been about what can you do about this shared driveway and the impact on the wetlands. And in fact, a number of commissioners have brought up, repeatedly, what about access from Brookwood Lane? So we provided 2 alternatives that have access from Brookwood Lane.
Thank you. I think Commissioner Redden has a question.
Yes, Commissioner Ritter, thank you. So on your plan from SE Minor, are you eliminating the current existing driveway?
Yeah. The only part that is there is where the gate currently is, the stone gate, would go to what is lot number 7, and but everything else where the driveways curves down and goes around and goes, all of that is eliminated.
Understand. Thank you.
Very good. Do we have any more questions for the interveners? If not, I was going to suggest that maybe it makes sense to ask Miss Burns to speak if she would like to, as it follows on what you've been saying about the alternative plan. So I believe she's...
Hello there. Can you hear me?
Yes, we can.
Lindsay.
We can hear you. I'm not sure we can see you.
I apologize. I've just had a sinus operation, and I think that it's kinder to not see my face, I must say.
Well, I wouldn't put it quite like that, Miss Burns, but we do appreciate the circumstances. You may prefer that we don't ask you to turn on the camera, and that's just fine.
Well, I think it's unsightly. Unsightly might be a good word. I just wanted to follow up, as I am very, very I just cannot voice without sounding like a desperate plea, but for the protection of the wetlands. And
I'm sorry to interrupt you, but perhaps you could just start by introducing yourself and just briefly saying what your credentials are.
Hello, my name is Lindsay Byrne. I am a trained landscape designer, studied in London, England. I am also own my own business and a practicing residential landscape designer in Connecticut. I have submitted drawings to the commission that I hope serve as an alternative proposal to the applicant's development submission. And I wish to convey, in my professional opinion, that my submission, which unlike that of SE Minor would be to leave the existing driveway as it is, and that's running through a new green belt easement, which is what I'm proposing, because I do think that the removal of that driveway and the time of getting jackhammers, diggers, trucks, all of that puts more impact on the wetlands. There was also a study done in that was referenced in the New York Times, January 24, 2012, done by a doctor and his colleagues, Dr. Moreno Mateos, who is currently teaching at Harvard, and he states that it does more damage to create, to do renovations to wetlands, to restore wetlands, than it does to leave them as as it is. Those wetlands on 82 Brookwood Lane have been functioning for decades, and it has been stated by meta-analytical database that studied 115 studies. One was of those, 80% of those were done in the US, but 25% less productive than natural wetlands. That restored wetlands are 23% less carbon than untouched wetlands. 26% of restored wetlands have a lower variety of native plants, and that's after 50 to 100 years of restoration. That plants take so much longer to return to their normal and established carbon resources in the soil to make a healthy ecosystem. And that even after 50 years, after a restored wetland has significantly lower carbon levels, which are needed for this plant material. So I just think that leaving the existing driveway where it is and reducing the amount of homes, which is why, I showed on my sketch only 6, and having that driveway end before the new driveway that's being proposed with the loop ends there at what I called the 6th lot.
Thank you very much for that, Ms. Burns. Before I see if there are any questions from other commission members, I would just like to say we do value your input, but you're not an intervener in this. You are a
No, I'm not.
neighbor. You are a neighbor, and you do have some professional credentials. But
Well, she's married to an intervener. Pardon me.
It's Spencer's wife.
Well, we're all married to, a lot of us are married to somebody. So we very much value what you have said, and your thoughts about an alternative. But as far as the record is concerned, we have to look at what is in the record when we make our decision, both from the applicants and from the interveners. And the interveners in this case are Mr. Grimes and Mr. Freeman. Nobody else signed the petition for intervention. But let's see if anybody has questions for Ms. Burns. Commissioner Sanford.
I'd like to go back to Rob when it's appropriate to ask him some questions.
Yep. Well, why don't we do that right now?
Hi. I want to make sure that I got the 3 arguments, the 3 reasons, and just to really kind of distill it and simplify it. The first is that you're arguing that we should evaluate impact, but not adverse impact.
Do you want to say all 3? You want me to?
No, that's one at a time,
Fair
probably
enough.
a good way to go.
We're suggesting that there's a defined term, significant impact, which this commission began to discuss in February, and which the applicant and the interveners have consistently discussed and disagreed on. And never have they said that never has the applicant said that the reason that the significant impact designation by this commission is because that's not necessary, is because we're doing a public hearing and we can't find it in the regulations. I'm very sensitive to this. I work with attorneys regularly. I'm not an attorney, and I'm questioning what Attorney Gelderman said, and I do it respectfully, but we are unable to support or substantiate that decision. So that's the first point, that the commission should be considering significant impact, despite the fact that this is a public hearing, or in addition to the fact that this is a public hearing.
Okay. Number two is that you're arguing that we should evaluate inevitable impact, which is really relies on the fact that there's wetlands on all 9 of, lots or potential lots as defined by the applicant. While, we're just instructed by our attorney to look at the infrastructure that's being built with the driveway.
Again, Commissioner, the regulations, we didn't make up this phrase inevitable. It is in the regulations, section 12.2 and elsewhere, I believe. And our point that our advisors have submitted to the commission, and which we're saying in sort of plain language, because that's what we're capable of doing, is that this roadway that has been proposed, this shared driveway, is solely for the purpose of accessing lots that homes are going to be built on. And it is our view that it is inevitable, the phrase that's in the regulations, that that's an activity that will take place. As Ms. Zabatakis and others have said, it's very speculative, despite the fact that their plans show, areas where conceptual, as they call it, conceptual 6-bedroom, 3-car garage homes will be. That's fine. The point is that they're not putting a roadway in for nothing. They're putting a roadway in to access homes. And we're suggesting that there is case law as well as the regulations. Actually, we should start with the regulations, that the regulations suggest that where there's an inevitable activity, that it's necessary for the commission to consider the future impact of that inevitable activity. And then we asked council to also provide case law to that effect. I'll note that the applicant has said that they read the case law differently. And that's, I guess, that's what, happens in courtrooms. But that is our argument there. So that's point number 2.
And the third is that the applicant did not consider alternatives where they removed they did not have the shared driveway and had fewer houses. And you have ostensibly presented 2 cases, one with 7 homes, which we have in our record, and one with 6 homes, which we don't.
Correct. That's correct. And again, the regulations state that and actually the reason for the argument flows that if there is a designation by the commission of that there may be a significant impact, as the commission talked about on February 24th, then you get to looking at alternatives. And the applicant has, again, repeatedly placed in their filings that there are no prudent and feasible alternatives. They did, as we all know, they did present at the last meeting, I believe it was, an alternative. It had the same shared driveway. And then it also showed accessing why they did not choose to access from Brookwood Lane, from the western portion of the property. And it was because of the stand of 91 trees, which are there. They're down the street from my home. But and what we've done is looked at that and said, well, you actually can have your cake and eat it too. You can have the access from Brookwood Lane and avoid cutting down those 91 trees. We all understand also, and the commissioners discussed at the last meeting, that what happens after the lots are sold is a different issue. Somebody may cut down the trees 5 years from now or 2 years. I don't know. But we've come up with an alternative. What we believe is a feasible and prudent alternative. So we believe that the statement that there are no feasible and prudent alternatives is just not factual.
Thank you. I'm going to ask Attorney Gelderman to address those 3 points, please.
Thank you, Madam Chairman. I'll go in reverse order. With respect to feasible and prudent alternatives, only if you make a finding of adverse impact to the wetlands do feasible and prudent alternatives come into the picture, because a feasible and prudent alternative needs to have less of an impact. So if you find that there is an impact, then you would consider whether there are feasible and prudent alternatives. If there's no adverse impact, then there's no need for an applicant to consider feasible and prudent alternatives. And keep in mind, applicants never provide feasible and prudent alternatives along with their application, because by definition, that means that the feasible and prudent alternative would have to be adopted if anything's going to be approved, because it's feasible and prudent alternatives only come into play if they're going to provide less of an impact. So the first finding is there an impact? If there is, then the commission would suggest to the applicant that there are feasible and prudent alternatives. Whatever they are is up to the applicant to present back to the commission at that point in time. So that's that. With respect to, I guess the second one was, well, the first one had to do with May. And it's there. I'm not sure why this concept has escaped Attorney Blank. He and I had a long discussion about it, and I thought he understood it, but maybe he didn't. Obviously, you're always considering in a public hearing whether there's an adverse impact. You can't deny an application because there may be an adverse impact. That would not be a legal or a valid decision by the commission. You can deny an application because it's likely to have an adverse impact. So this concept of may have an adverse impact is really sort of a red herring in a sense. It's the only time that the commission considers the concept of may is when it's considering whether or not to hold a public hearing. After that, once a public hearing is held, for whatever reason, the only standard that the commission is dealing with is whether activity is likely to have an adverse impact. And that has to be established through substantial evidence. So it's really not that complicated an issue. And I certainly would be happy to, and I did discuss it with Attorney Blank, but anyway, but that's what the law is. It's not that complicated. The third issue had to do with considering the inevitable development of the lots that are part of the subdivision. And as I said, you can consider that in the context of your report to the Planning and Zoning Commission. But in the absence of a specific site development plan, you have no ability or no basis on which to make a determination as to what those impacts are going to be until you have a specific site development plan. You can't assume anything, and you certainly can't deny an application because of some future activity that's undefined. You don't know where that activity is going to take place. You don't know what it's going to entail. And if you denied an application because hypothetically there's going to be a house here and it's going to impact the wetlands without any specific plan of what that house is, that decision wouldn't stand up in court. So you will have an opportunity to review each one of the lots that might have regulated activity on them down the road. So you'll have that opportunity. But the mere fact that the purpose of a subdivision is to ultimately develop those lots with houses doesn't make any particular development inevitable. It may make the fact that there's going to be houses, but what development is going to be there is not, there's nothing inevitable or certain about that at this point in time. The case law that, by the way, that Attorney Blank cited is not really law. It's Superior Court cases. The law in Connecticut is created through either statute, appellate court decision, or Supreme Court decision. Lower courts, superior courts, don't make the law in Connecticut. So, you know, that was an opinion. Whatever opinion a lower court, a superior court judge has is not considered to be law. You can cite that, but it's not defined law in the state of Connecticut. So anyway, hopefully that's clear enough at this point in time. But like I said, I'll be here for the duration if any other questions come up.
Thank you very much, Attorney Gelderman. I think it's time to move on and to hear comments from other members of the general public. We'll take one comment from somebody in the room and then one from somebody on Zoom. So is there someone in the room who would like to make a comment? So very patient.
I feel special.
Well, so why don't you go right ahead? If you
Sure.
please identify yourself.
Yes. Hello, my name is Justin White. I live at 37 Brookwood Lane with my family. In my 16 years of living in this town, I've never sat in on a Wetlands Commission meeting until recently with these meetings at 82 Brookwood. I would first like to thank you all for your service to our town. As I've witnessed, this commission puts in long hours of time as stewards of this vital environmental protection, and more importantly, all on a volunteer basis. So again, thank you. I am not opposed to development of Brookwood Lane, but as a large scale project that could last for more than a decade, I'm opposed to the developer's plan as it shows such a disregard for the open space and land that helps make New Canaan and our streets so special. This project will double the size of our street in terms of homes, and with removal of a substantial number of trees, change the views and purely the topography of Brookwood forever. As a group, we have spent considerable funds to provide alternatives that we believe protect the wetlands and also allow for plenty of development. I urge you to implement the recommendations made by our advisors at SC Minor and our attorney Adam Blank. Thank you.
Thank you very much. Do we have someone on Zoom who would like to make a comment? Please raise your electronic hand.
I see no one on Zoom with their hand raised.
Okay, well, let's see if there's somebody in the room. So the gentleman in blue at the back, if you would like to come forward and use the microphone so everybody can hear.
Hello, everybody. My name is John Herron. I am the president of the New Canaan Field Club. And I'm here representing the New Canaan Field Club. I am a member of the New Canaan community. I live in Putnam behind the YMCA, so I'm not personally involved as I'm here as a president of the Field Club. As a public statement, the New Canaan Field Club directly abuts the property that is subject to this development as a downhill neighbor to the south, specifically of Lot 6. We own the properties of 150 and 164 Smith Ridge Road. We are a 501c7 organization that includes over 350 New Canaan families as members. We are very concerned about the impact of this development, including but not limited to the construction of the new homes, outbuildings, pools, etc., and the new driveway/roadway. And the alternative of landscapes, removal of trees, vegetation from the wetlands, drainage perspectives, as the property is directly above our property and the general runoff is through our property. A recent example of our concern is that in August of 2024, there was a stream that flooded the creek that runs through our property directly from the subject property that caused over $250,000 worth of damage to our newly installed pickle courts, our driveway, and our paddle hut. I have pictures and insurance documentation if you'd like to see those. We're not with me, but I can get them to you. We are very concerned about the increase in building and the creation of impervious land above us. We are pleased to see the proposed work that the applicants have done to preserve, expand, and improve the existing wetlands. It is our intention to be good neighbors However, we do want the record to show that we have concerns, specifically as it relates to lots 5 and 6, and how the overall stream development will affect our property and facilities. We always want to work with our neighbors to strive to not impede their rights or make them unhappy in any way, while serving our member community and implementing development and programming that improves our member experience and satisfaction. Note the recent work we've done to build out our field house in 2018, add pickle courts this last year, paddle courts, as well as introduce low impact lighting on our tennis courts over the past 10 years. All of this work was done with our neighbors notified and in the scope of working with wetlands and P&Z committees, and have followed all the rules and guidelines and suggestions. So we thank you for the work that you've done with us specifically on all these projects. We want to work with wetlands, P&Z, the developers, and the neighbor groups to be a positive partner in this process. I'm stating it here, but we've made our intentions clear to all parties that we are interested in expanding our ownership, and specifically in lot 6 as it on the current map. We have no current or future intention to construct substantial impervious structures, i.e. dwellings, and mostly desire the property to expand our footprint, control the area between the club activities areas, our tennis courts, and the neighbors that create green space for our family members and the New Canaan community guests to enjoy, the New Canaan community and their guests to enjoy. In that lot, there's an inclusive of wetlands that we would obviously respect and do the same work to improve if we did end up becoming a larger landowner in this area. That's all I have. Do you have any questions?
Any questions, comments? I just have one question, and that is whether the field club has considered the enhancements that are being put forth in this application, whether that would have an impact on the amount of flooding that occurs onto the field club property through the daylighting of the stream, which should reduce the velocity of flow. As well as the fact that there's going to be a modern stormwater management system, which isn't the case currently, and which could be, contributing to the problems that you experience.
Yeah, one of the comments that I made, that we are pleased to see the improvement of the wetlands, the expansion of the wetlands. I said 3 things. I wrote this earlier. To preserve, expand, and improve the existing wetlands. So we hope that work does mitigate the impact. We've done substantial work to our creek bed. We've created basins to slow the water down. We've improved the flow. We've made mitigations for if it happens again, how do we divert that water off of our pickle courts? But we had just built these pickle courts, and then we had a 1 in 100-year storm, and we had it was a mudway. It was just a mudslide that came down from, not anyone's property, but it came down from above us. And so as a downstream neighbor to everything that's happening, absolutely, we hope that whatever those cool terms you just said make a lot of sense, but like something about light and flow and all that stuff. But again, we're still concerned mostly about the impervious creation. I know the inevitability of impervious, what this gentleman was talking about, there'll be less ground to take up the rainwater if 9 houses are built up there. So we're very concerned about that, down 5-10 years down the line as those houses are built. But yeah, in terms of, we're very concerned about flow of water downstream.
Well, thank you for that. Sorry about the new paddle courts. We seem to be having a lot of 1 in 100-year storms at the moment.
Yeah.
Yeah.
We got them cleaned. If you want to play pickle, you're our guest. All right. Thank you.
So who else would, I think actually the gentleman over here in the gray, Mr. Kavor, hi, Kavorhin, had his hand up a little earlier, so please. And if you could introduce yourself so that I don't mangle your name any further.
Good evening. My name is Haik Kapukjian. I live at 293 North Wilton Road. I have a question for the soil scientist, Mr. McKinney. For a large tract of land such as the Brookwood property, how do you go about deciding where to sample land that may or may not represent wetlands? Or to put it another way, is there a protocol that you?
I'm so sorry to interrupt you, particularly right at the beginning, but I'm afraid this is an opportunity for you to comment, not to cross-examine the applicant and their experts. I mean,
Okay.
if you just mention your concerns, maybe that is something that in the applicant's, wrap-up remarks, they can try to address, but they do need to be, comments from you as opposed to questions that sound like cross-examination.
Sure. My intention was not to cross-examine Mr. McKinney, but thank you. I also have three additional comments. When I listened to recent testimony, I was surprised that the fire marshal and chief allowed the eastern driveway to be only 18 feet in width, which seemed considerably less than the state of Connecticut allows. While advantageous to the applicant, I cannot understand how that would be good for the general public. If this was a compromise which was done to not encroach on the wetlands, then perhaps there should not even be a driveway there. In a recent meeting, the developers team mentioned that in the winter, to protect the wetlands, that salt, and I assume they mean sodium chloride, would not be used on the roads, but instead calcium chloride. I cannot imagine a neighborhood association will be able to monitor this in a consistent fashion. It was also mentioned that roadway runoff would be directed through a series of mechanical filtration systems that require periodic maintenance. It is also equally hard to believe that the neighborhood association is going to have the focus to periodically address the filters depicted. It is also hard to imagine that people would be willing to pay the expense of that maintenance or even remember that it has to be done. I feel these last two items need better thought in terms of policing. Thank you.
Thank you very much. And we have somebody else, I believe, at the back who would like to speak.
Yes. My name is Patrick Donovan. I'm a 32-year homeowner in New Canaan and the last 24 at Brookwood Lane. My wife and Jennifer raised our kids there, great street. We were at the meeting, the P&Z meeting that was referred to, and let me just get this out of the way. There were three reasons why people were there. One, a fence was put in by Gears developer, construction people that I don't think he was aware of. It went all the way to the end of his property. It made a blind turn, was very dangerous, and lots of folks on the video wanted to just make that point that it was dangerous, and he changed it. The other thing was his trees. We wanted him to address his trees. We almost missed Christmas. I believe this was in 2022. And the other reason, the third reason was, I think there was just a lot of curiosity about meeting an officer and a gentleman. And it was clear that that was going on. As a matter of fact, after the meeting, Attorney Rucci called me and my wife over to meet Richard. I met his wife and him, gave him restaurant recommendations. So the fact that we were supposedly against what he was doing is nonsense. As I said, my name is Pat Donovan. Thank you very much, folks, for your diligence and service to your fellow residents of New Canaan and the environment. You folks are the definition of self-government. We wouldn't have a wonderful town, and the United States would not be what it is if it wasn't for people like you. So thank you very much. And whatever you decide, thank you very much as a resident of New Canaan. We are truly blessed to live here, and we're blessed to have people like you willing to put in all this time, which is very thankless. I'm sure you'll agree with me on that. This is a big project, as Justin pointed out. At its most optimistic, it's a project that's going to take years of construction and disturbance of the environment. I don't have any alternatives, but my concerns are the same as yours: the impact to the environment, expanded impervious coverage, roofs, driveways, patios, pool decks, acceleration of rainwater. I live on the other side of the land, not what you guys are necessarily worried about, but I know when those driveways will come in, that water will be accelerated onto my side of the hill. My side of the hill, all the water comes through my property as well as my neighbors on its way to the mighty 5 Mile. My hope is that there is development with less loss of trees, preservation of more open space, more impervious coverage. I urge you to consider other alternatives, and I humbly thank you for all your work. Thank you.
Thank you very much. Is there anybody else in the room or on Zoom who would like to offer comments? Let's just check on Zoom for a minute, make sure we're not missing anyone.
I have no indication of anyone on Zoom.
Very good. Well, that means that it's time to invite the applicant to come and make some concluding remarks. Just wait for the team to assemble. Zapatakis.
Yes.
I just have some questions that I hope you might be able to cover in your remarks, and maybe you already plan to do so, but if I could just briefly set those out. Firstly, when does the applicant propose starting and then completing the shared driveway? What might delay the start date? When does the applicant propose to start daylighting the stream and restorations of the wetlands? Basically, where's that going to occur in the sequencing? You may have covered this already in what you submitted to us, but if you could just talk about whether the alternative that you presented includes daylighting of the stream and restoration of the wetlands, including removal of the existing driveways. And then the last question is a very technical one. Has Micropool 1 been resized? And it may be that other commission members have questions or areas that they'd like you to cover in your remarks. If so, now would be a good time to voice those.
Angela, this is Dan again. I'm looking at the application and the description of the application, and maybe this passed over me, or I wasn't present for the last meeting. But one of the things we want to discuss here is the installation of power, communication, and data utility lines. Has that been addressed? And if it has, give me some background, or somebody can give us some background on that.
They can do.
Right. Good. So over to you, Attorney Zapatakis.
So thank you very much. And I will say thank you very much for all the time and effort that the commission has put into hearing these presentations. I know this has been quite a few meetings, so we appreciate all of the time. I actually was going to open it by my presentation tonight just simply by saying that I do think we've submitted all of the information and ask if you have any questions. So I think probably the best thing is for us to go into the questions that have been asked so far, and then if there are any others, we can address those. And then I do have a couple just some summation remarks, and I know I want to have Mr. Kenny speak at the end. So I'm going to let Mr. DeAndrea take a look at the micro pool. I can answer, you did have one of the questions that you asked was whether the alternatives include remediation. And no, they do not. When we first came before you, we had a plan that involved some wetlands elimination because we were widening the driveway to 18 feet all along. Mm-hmm. When we got feedback that was something that was not desirable, we were able to confirm with the fire marshal that he was okay with a driveway that was not 18 feet for its entire width. And by doing so, we have eliminated all of our wetlands elimination. And I apologize, that was a triple negative, but there is no wetlands elimination in the plan. All of the proposed work that is before you as far as the permit is work within the upland review area. So candidly, had we come before you at the beginning with with work that was only in the upland review area, we would not have had such extensive wetlands remediation. Because we started that way, and because frankly, we do think that that is a good for the site. Mr. Kenny obviously is very happy with what we're proposing as far as the remediation. That remediation has remained and in fact has been expanded through the course of our proposal. But no, if we were to engage in an alternative that was more costly because of having to install new driveways, having to remove significantly more trees, there would be no reason to engage in the extensive wetlands remediation that has been proposed. So no, I don't see that being part of that proposal. Do you have an answer on the micro pool?
Oh, sure.
Because I'm going to ask these guys about the other.
Lindy, Andrea, we didn't eliminate or change the design of it. We have done some tweaking. So we didn't want any encroachment into the wetlands. So all we did is kind of massage and reconfigure a bit so that even our discharge points would be outside of the wetlands. I always like to comment on the maintenance. Associations are great for maintenance because you develop that drainage maintenance plan, which is very common now in the neighboring towns, Stanford, Greenwich, New Canaan. And basically what it does is, as you hire your landscape contractor, this is the protocol, this is the price they're going to give you, and these are the applications. Sodium chloride is totally unnecessary in this day and age to be used in the roads. Calcium chloride is fine, not sure if it's that necessary. And then we have all these redundancies in our design because of the comments received from this commission and from the consultants hired by the neighbors. We've worked in redundancy. It starts out with a development this small, and truly is in our mind this small. Catch basins with sumps and traps sometimes are fine. Maybe it requires an insert. Those inserts are typically required when you have quite a bit more traffic and typically for parking lots. But we've gone beyond that. So now from those, you go into the more of the lid and BMPs, so you have a natural polishing. So you run it through your micro pools, and now you have nutrient uptake, infiltration. Whereas take an infiltration system itself, which is just these dry wells in the ground, what you get out of that is just groundwater infiltration and maybe preceded by a basin. So in this case is here, we look at this now as being a very well-designed system with redundancy. And again, these are designed just for the driveway. It's not taking the individual homes. The design requirements are very strict in New Canaan. It's great. It used to be that we didn't have to control volume. So there was a comment about how much water is coming down. With this design, we already show a reduction in volume. And in each lot that we develop, we not only have to take care of water quality, peak rate of discharge, but now volume. So that means it's zero or less volume will be leaving the site that we develop in the future, as is there today. And I think your town engineer made it very clear. We're starting from undeveloped sites. So that's the criteria. If we put a house on here and a driveway, we have to design a system that controls peak rate of discharge, provides water quality, and volume control. Thank you.
May I ask one quick question on this topic of the stormwater maintenance? I don't know what you call it, the maintenance agreement that ultimately may be developed should the homeowners association be developed. Would the applicant be willing to provide a copy of a draft of that agreement to the town?
That would be a requirement. As far as the ultimate, I think you've provided some drainage information, but yes, one of the requirements that we will have when we get to the final process will be approval of the homeowners agreement, because that will also include our conservation easements and open space. That'll be reviewed by town council. I would certainly, that is typically a planning and zoning condition, but we can certainly include your office in that review as well.
Okay, thank you.
And I actually, that ties into my responses to the first two questions that the chair asked about sort of the phasing as far as starting the driveway and the daylighting of the stream. You know, my clients would like to get started as soon as possible. We're not done with this process, and we still need to finish with planning and zoning as well. So assuming we get the approvals, they would start relatively soon thereafter. As far as any sort of phasing plan, that's definitely something that will need to be developed. I think that would be an appropriate condition of approval. And as far as, you know, the timing of some of these elements, we would work with staff on that. But the idea is to get everything moving as soon as we can.
Thank you.
Currently, that is a drafted recommended special condition is a phasing specific to that.
And I think the last question that I heard from the commission was a question about the utilities installation, and that has been in the plans, but obviously wasn't something that was directly addressed. So I'll have Mr. DeAndrea address that.
Right. So bringing the power to the various lots, there's basically two ways. You can do it with overhead power and installing utility poles, which we do not want to do for a number of reasons. One, subdivisions, new subdivisions typically require us to do it that way when there's a roadway involved. We don't have a roadway, we have a driveway. But two, that's certainly more disturbance on our part. As we see it, you have to come in with the big machinery, install poles, string all the lines. You have cable vision, you have the electric company. Instead, you go in and you dig a shallow trench and you install typically 2 conduits for electric, maybe 4 other conduits for communication. And you bring it to certain locations for splicing and transformers, and you move on. It's installed quickly, it's backfilled, and it's done. So we would see that as being part of the first phase. I think one of the things we would do too is put a binder course down if there is if we're installing a driveway, like at the very beginning, put that down initially so that you can drive your vehicles over it, and then do patches where the existing driveway is and leave that to a point where all that work is done, and then come back and remove the asphalt and put down the new asphalt so there are no patch lines. So conduit first, and then probably the final paving, maybe a year later, something like that.
Can I ask a question? Are you planning, and this may have been spelled out on documents earlier, traditional asphalt or like polymer modified asphalt, or what are you looking at options, or what is the least environmentally damaging? We
may use porous pavement on the individual lots, but in this case, we didn't need it because we had enough room to do these natural biofiltration areas, the 3 that we talked about. So no, in this case, we didn't want to do permeable pavement. Didn't see that being necessary.
Any other questions?
So just to clarify, how long will the process take from start to finish? So the shared driveway and then the restoration of wetlands?
I don't know that we can give you an exact timeline right now. You know, a lot of it depends on when we start. You know, there are certain things that you want to do in the spring. There are certain things that you're going to want to do during the summer. So there's going to be some phasing that will need to be worked out with seasonality. You know, again, my clients do want to get this part of the project done as quickly as possible, because that is when they'll be able to start marketing the individual lots. So there's not going to be any reason to delay. And it is anticipated, based on the way that this application's been presented, that all of the remediation work is tied into the driveway work.
So having the permits and starting the work are preconditions for really marketing the lots. Is that correct?
Correct.
Thank you. Do we have any other questions at this point? I know that Attorney Zabitakis wanted Mr. Kenny to speak for a few minutes.
Sure. So I'll just sort of sum up where we are. I actually, a good part of what I was going to say, I believe Attorney Gelderman is really covered, so I'm going to try to skip around a bit. But as he stated, the two items in front of you are the permit for the work we're proposing in the upland review area and then preparing a report to the Planning and Zoning Commission on the proposed subdivision. As I stated, we have presented a plan with no wetlands elimination, substantial wetlands remediation, and according to our expert, there will be no negative impact on the wetlands. And there will be, in fact, an improvement to stormwater, an improvement to the functioning of the wetlands. Under section 12.21 of the regulations, you may not deny or condition an application for work in the upland review area unless such activity will likely impact or affect the physical characteristics of the wetlands or watercourses. That's the standard. I don't believe that there is any way to show that this will likely impact or affect the physical characteristics of the wetlands. You have the expert testimony from Mr. Kenny, and now I will have him speak again. And so I don't really think we need to go further with the analysis. There's been a lot of discussion of feasible and prudent alternatives, as you heard from Mr. Gelderman. Those should only be considered if you determine that this activity, again, the permit we're requesting, is likely to have a significant impact on the wetlands. That's in section 12.3. Not just that it may, not that it will, that it is likely to have a significant impact. So I don't think we get to the reasonable and prudent alternatives. I don't think I need to discuss further why I think that the alternatives that have been submitted are not reasonable and prudent. One of the considerations for reasonable and prudent alternatives is whether they're economically prudent. And whether they're environmentally prudent. The alternatives definitely would result in far more disruption to the property as a whole, greater tree removal, and would not include the rehabilitation that we've discussed. The other part of this is the subdivision review. The number of lots within the subdivision and the layout of the lots and the open space, those are all matters for the Planning and Zoning Commission. They will be reviewing this after you're done. We have demonstrated both the Planning and Zoning Commission and to you that the lots have been designed in accordance with the town's regulations, and they have been designed such that they can be developed without any elimination of wetlands, without any work even in the upland review area. However, you will see these lots again. I think it's interesting that you actually have on your agenda later on this evening, 277 Greenlee Road. That's a subdivision that I handled back in 2017. This commission approved a shared driveway in the upland review area to serve the 4-lot subdivision. And that was approved back in 2017. And it's just now that the development of those lots is being proposed and the individual lot development is coming before you later on today. So that is the process. That's the standard process with subdivisions. We're not trying to trick anyone by doing it this way. This is the standard process. And it does give you an ability to look at each one of these lots. And as Mr. DeAndrea mentioned, the New Canaan regulations are quite stringent as far as when those lots are developed, when a proposal comes forward, making sure there's no adverse impact on the neighbors, no adverse impact on the wetlands. I think that this is a environmentally sensitive application. Our goal at the beginning was to minimize disruption to this property by reusing this driveway and expanding and improving on the wetlands that are on the site. I believe that that is what this application does. And I'd like Mr. Kenny to just summarize his professional findings regarding the impact of this application. Thank you.
Good evening, Bill Kenny. I thought I'd share with you quickly. Well, I'm going to have 3 primary conclusions that I want to share with you, but also just to share with you a little bit more of my background. I'm before you quite a bit, but there were some questions about the success of or common success for wetland restoration or enhancement work and things like that. I want you to know I've been doing this more than 30 years, and my focus in grad school at Yale School of Forestry was in wetland restoration and hydrology, understanding how water moves through the landscape and how we can restore degraded habitats. So I've been doing this for 30 years, and we've had great success with this, particularly in situations like this, where if it's a wonderfully high functioning wetland, we're not going to be able to create something equal to that. But when you have wetlands that are degraded, it's great opportunities to bring them to a higher functioning. So I'm very confident that what's being proposed will have significant benefit. So with that said, also, my conclusions are based on those existing conditions, the degradation of many of the wetlands on the property, the location of the existing driveway that's proposed to be modified in some areas, but substantially will remain as it is today. With the major improvement of today, there's no collection of water running off of that driveway and being cleaned before it's discharged to wetlands or water courses. So with the modification, we're going to collect that water, we're going to clean it before it's discharged. And then we're going to take these substantial areas of the wetlands that have been degraded and bring them back to a much brighter and higher functioning. So with all that said, I'll start with, I do conclude that this project will not have the effect of unreasonably polluting, impairing, or destroying the public trust in the air, water, or other natural resource of the state. And then I want to say very strongly that it's my professional opinion that there will be no adverse impact to the inland wetlands or water courses, whether they're on the site or off the site. We have no wetland loss, and we're providing substantial improvement, over 17,000 square feet, certainly over 20,000 square feet of restoration, enhancement, and improvement, starting at the southern end of the site and moving all the way up through the central portion of the site to the northern end of the site, stopping at several places along the way to make improvements, which will help to reduce flooding downstream. We're going to really be expanding the ability of these wetlands to hold back floodwaters as they make their way through the property. Next, so I've mentioned the two things, and lastly, that it's my belief that the wetlands will be improved, that there'll be more wetlands on site and higher functioning wetlands on site. So overall, the wetlands and watercourses will be improved with this proposed project.
I think that is all, unless there are any other questions.
Do we have any further questions for Attorney Sabatakis and team? Because this is as a commission, this is our last opportunity to ask questions before we close the public hearing. No? Any last words from the applicant?
No, I think.
Fine.
Angela, can I ask a question? This is Dan.
Sure, go ahead.
I just want to make sure I understand, are we using the word adverse in our terminology now, adverse impact? Or I hear just the word significant, and that can go both ways, adverse or positive. I'm just wondering, Attorney Gelderman, and you used it now when you just talked to us, but other people are just saying significant impact. What are we using?
No, it's adverse, Dan.
Adverse, okay.
Yes. The key is adverse impact.
Okay, good.
Good. Any further questions? Okay, so with that, I will close the public hearing on 82 Brookwood Lane, and it will now be for the commission to deliberate, which we will do right now and see how far we get. But this is probably a very opportune time to take a 5-minute bio break. So see everybody back at 8:45. To work. There has been some discussion about whether the chair can close a public hearing or whether there should be a motion that the commission considers. So now I'm going to ask someone to make a motion to close the public hearing.
I will make a motion to close the public hearing, although my understanding in the past is that the chairman closes a public hearing, but just to be safe, I'll make a motion to close the public hearing.
Thank you.
I second.
Thank you very much. Oh,
I second the motion.
thank you very much. All those in favor, please raise your hand. Aye. That is covered, so unanimous. We hereby close the public hearing and we'll move on to the commission's deliberations. So we have a number of things to consider, but first we need to consider whether to approve or deny the application for an inland wetlands permit. So let's start with that. And I suggest that we just kind of go down the line and see where people's heads are at this point. So this is not a vote, it's just you expressing your point of view on the application and the evidence that we have heard, both from the applicant and from the interveners experts. So who would like to start? Commissioner Redden.
Yeah, thank you, Madam Chairman. I mean, I was making notes and I believe based on the materials presented and specifically from the applicant's professionals, Mr. DeAndrea and Bill Kenny, their testimony, I don't believe the activities proposed by the Burkwood Group will have any significant negative or adverse impact on the wetlands. In fact, I think that Mr. Kenny's done an unbelievable job, and I've been around just long enough to see he's doing a job above and beyond what they need to do. So I think the impact is actually going to be very positive, bringing this back to what it used to be, reducing the water flow, daylighting taking the pipe out. I don't believe the applicant needed to go that far, so I applaud them for going that far, and I'm pleasantly surprised that they're working with us.
Thank you. So other commissioners like to express where their heads are at right now?
Angela, I'll go if you want.
Thank you.
I've been very impressed, like Sandy has, with the applicant. They've got their their presentations together. They acted as a team, and I just can't see any adverse impact to the phase one. I consider this phase one of a two-phase application, or application number one, and then there'll be an application number two. I'm very impressed with them, and I just don't see any adverse impact. And the interveners, they did a fine job, but I don't agree with some of the things they said.
Can I continue?
Thank you. Yes. Oh, Commissioner Rendon has some additional
I just want to add on to something that that was just said. With the alternative that was presented by the interveners, which they don't need to do that, and they went above and beyond trying to do that. But they want to remove, if I understood that correctly, and I asked specifically, they're removing the existing driveway. That and then we were heard, someone's going to come in with diggers and backhoes and jackhammers. Well, that's going to happen to remove that, and that would have an impact of one way or another without addressing drainage or daylighting the stream. So I thought that was actually a negative. Just to carry on what Dan was saying.
Thank you. Commissioner Sanford looks like she would like to speak.
So as commissioners on the Inland Wetlands Commission, we have to adhere to the statutes and to the advice of the town attorney. And so if you go through the list of what we need to consider, one is in terms of whether there's adverse impact on the wetlands and watercourse. And I would say in the course of the hearing and in the whole presentation by the applicant, there has been no evidence that there would be that adverse impact. And one really would like to believe that the restoration of 17,700 square feet of wetlands with 0 square feet being lost, as well as some of the other wetlands improvements that are part of the application, will in fact improve the wetlands, and along with the water management system, which will be much better than that we have now. And considering that we are only to evaluate this phase of the application, which is regarding the building the infrastructure of a shared driveway and working off of what exists and expanding it in just the places they can, which does not impact the wetlands, that there's nothing that stands out that would lead us not to accept this application as it is defined today.
Thank you. Who would like to go next? Commissioner Owsley, thank you.
I would like to agree, probably less eloquently so, but with Beth in that I really felt like the issues that the town attorney laid out for us really move this out of our purview. There aren't going to be significant adverse impacts on the wetlands, and therefore the other considerations are not within our purview to consider right now. So I too would be in favor of approving, although I believe that one of the more recent filings we had some suggested conditions, maybe from Maria or from you, Kathleen, on them. Okay, so.
Yes, Beth Sanford here, just to build on that, which is that I do think there should be some stringent set of conditions and surveillance that would go along with the construction of the driveway and the whole management of the project.
Thank you. Commissioner Ramirez.
So we've heard a lot of testimony and had a huge stack of materials to go through to consider everyone's point of view. Certainly both sides have put together compelling arguments, but we're talking about the wetlands, and that's what our purview is the wetlands. And if the wetlands are being restored to a level of functioning that they didn't have in the past, this property has already been developed and has a number of structures with impervious surfaces on them. The only thing that sticks in my mind is for future development. Certainly the gentleman from the New Canaan Field Club, they have concerns about runoff and any substantial impervious surfaces not being mitigated and flowing onto their property. And that really, to me, is the only concern I have over this property. I think everything else has been addressed and has been mitigated. So again, my main concern is simply what happens to the downstream flow of waters, again, because I don't know what's going to be built on those 9 lots. So that is not fair to whoever is in lot number 6 to have to build substantial infrastructure because everybody else's lot is flowing into their lot, and it's the lot next to the New Canaan Field Club. But that is just my observation. But overall, I think that as a member of this commission, that I would be in favor.
Thank you. Commissioner Williams.
Yes, Commissioner Williams, I agree as well. I mean, we've been provided with a lot of information, site visits, et cetera. And I, given Attorney Gelderman's parameters of what we're deciding on, which is wetlands, I cannot see any reason why we would not approve this. It's, no significant impact to the wetlands. And what's being done has gone well above and beyond. So, yeah, that's.
Well, thank you. If I may just take a couple of minutes to tell everybody how I am seeing this. I do not believe that the interveners provided substantial evidence that the proposed activities would likely adversely impact the wetlands. And there are a number of things that have emerged as discussions took place with the applicant that I think lead me to the conclusion that there will not be an adverse impact on the wetlands. The proposed shared driveway really has been narrowed to the extent consistent with fire safety standards. It's not going to intrude on the wetlands, although its edge will in certain portions abut them. And as per the December 2024 Wetland Impact Assessment Report by William Kenny Associates and the letter from Bill Kenny of the 31st of March, the existing wetlands clearly have degraded in functionality over many decades, starting with the use of agriculture and then the way in which the estate itself was developed. In his December 2024 report, Mr. Kenny noted that on page 7 that there have been large changes and manipulations of drainage patterns within the site that have changed the hydraulic conditions. The introduction of man-made drainages and the fragmentation of wetlands with roads and other development has left present wetlands much drier than they were historically. The piping, channelization, and armoring of the stream has also contributed to quickly conveying water off the property and broadly drying the landscape. So these wetlands still provide aspects of their former functioning, albeit these wetlands have been greatly reduced in capacity since the modifications to and management of the landscape began. So we're not talking about, a pristine, significant wetlands here. And in my mind too, it's really important that the applicant has proposed several activities that will enhance the functionality of the wetlands. The modern stormwater management systems will do a better job of protecting the wetlands than the existing driveway that really doesn't have anything very much in the way of managing stormwater runoff. So that is a big improvement. I like the fact that the stream is going to be daylighted. That will really improve the functioning of the wetlands surrounding it by allowing water to overflow the banks of the stream in heavy storms rather than exiting through the pipe section at high velocity and flooding downstream areas. I think it's very important that 17,700 square feet or so of high functioning wetlands will be returned to the property by removing fill and soil, including the removal of existing driveways, as well as the invasive Japanese knotwood. And then the planting plan will help to restore and enhance wetland functions. And the total planting and enhancement activities will cover some 61,600 square feet, according to page 5 of Mr. Kenny's letter of the 31st of March. And I was also struck by the engineering reports from DeAndrea. We had a number, the 14th of March, the 18th of March, and then the 28th of March, providing evidence that the proposed drainage system will provide treatment and infiltration of runoff from the new impervious surfaces and control peak flows to those of no more than existing conditions. But I do think we need to talk very seriously about some special conditions here, because it's important, in my mind in particular, that we seek to ensure that the homeowners association will really take care of the land that is owned by the homeowners association, and which consists of, a lot of it consists of wetlands. So it seems as though we're all pretty much of a mind that there is no substantial evidence of an adverse impact on the wetlands. So maybe we should spend some time going over the draft special conditions that Director Holland has proposed, and maybe we should ask her just to run over those with us.
Does everyone have a copy of that or access to it? I think I may have put it at your seats there. These are in no particular order, as everything was happening very quickly on this application. I was writing reports as quickly as I could write them. So these are just some recommendations of special conditions that we actually have used on other applications and apply to this application as well. I also asked the town engineer to opine on some of these conditions, so she also helped me with a couple of these here and the wording. So number one, the engineer of record.
I did see it, but where is it?
It's the April the 4th staff comments. It's on the 3rd page.
I probably haven't.
Interrupt you.
She's gonna read them.
All right.
Kathleen, are you gonna read them?
I didn't put everything out.
I didn't give her one. Beth? Does anyone else need another one? We're just getting organized, Dan.
I'm good. I've got mine.
I'm fine. Sending you okay? Yeah.
Does Dan have it?
Yep, well. Okay, proposed special conditions. Number one, engineer of record shall organize a pre-construction site meeting prior to implementation and include the site engineer, site soil scientist, town wetland agent, staff, property owner, and site contractor. So we often do pre-construction site meetings just to make sure everyone's on the same page. We're gonna get off to a good start. At this point, we're meeting the site contractor, potentially whoever actually gonna build that road. So we're kind of making sure they're aware of the special conditions on the lot where all the wetlands are. So I think that is a reasonable special condition, and often it's done on projects of this size. Number two, applicant shall provide a detailed phasing plan to staff prior to implementation activities related to the proposed driveway and mitigation. This construction logistics plan should include construction sequencing, proposed erosion and sediment control measures, location of temporary stockpiles of material, will wash down areas, etc. There's pretty much a standard for a phasing plan, so I believe Mr. DeAndrea will be able to provide the things that we're looking for in that plan, and they stated so on the record as well.
This is Angela Jameson for the record. So this is where we would include in this the phasing of the restoration of the wetlands and the daylighting of the stream.
Correct.
Correct. Good. That's part and parcel of that one. Good.
Oversight shall be provided by the engineer of record and landscape architect of all construction and planting activities until completion. Often the oversight and the timing of the oversight is discussed at the pre-construction site meeting. So we will come up with a standard for when they would be doing their inspections, sort of as they get into their project. But the point is that the oversight is the engineer of record and the landscape architect. In addition to, our staff will be going out and doing inspections as well, but those technically qualified people should be providing the oversight, especially on on those two special areas. I know I'm combining the two, but that's the project. It's the roadway and also the mitigation planting plan.
And so DeAndrea is the engineer of record, and the landscape architect is William Kenny Associates?
Correct.
Thank you.
Upon completion of construction activities, the engineer and landscape architect shall certify that the roadway and mitigation plans have been properly implemented and provide final written reports to the town staff for review. Number 5, the applicant shall provide a site monitor to conduct inspections of all soil and erosion controls at a minimum of 2 times per month and inspect and report before and after rain events of 1 inch or greater. The site monitor shall submit written reports on a monthly basis to town staff. So again, that's sometimes something that is more detailed at the pre-construction site meeting, sort of the logistics of that. There's usually a standard form that's used, and the engineer can provide that on their records. But it's more so that we're getting reassurance that they're on top of their project, they're doing their monitoring, inspecting of the soil and erosion controls and responsible for those things for the duration of the project.
Can I ask a question?
Could you put your mic on?
Sorry, a question for Kathleen. The site monitor will be reporting to the landscape architect or to the site engineer? Who is this?
So the site monitor could be the site contractor. So the developer will appoint somebody as the site monitor to make sure that they're in control of all the soil and erosion controls that have to be done on the site. So they would, if there's an issue, they would report it to the person on the site to correct it. Also within the standard license that we provide to any applicant, that they have to also provide that to our office. If there's an issue, they have to notify us. Oh, we had a blowout over in this area, we've corrected it, we're fixing it, we're doing whatever. So the timing is really related to rain events. So sometimes when we get those big rain events, so 1 inch is a standard or greater these days. So so they would both, they would provide the information to, so town staff, do you mean like me? So is that what so you want more specific?
No, well, I was just trying to understand if that person was independent or an employee.
So it's,
one or the other.
They're their employee. Yeah, it would be the owner's employee providing the information to the town staff, either the town engineer or myself.
Okay, thank you.
We probably would loop in planning and zoning as well. We'd make sure that this report and that everyone's on top of it so that we're all sharing the responsibility. Submit final A2 survey upon completion of construction activities with all infrastructures and improvements located. That's pretty standard. Last one, the applicant will finalize their stormwater maintenance plan prepared by DeAndrea Surveying and Engineering PC, originally dated December 6, 2024. The plan should clarify the responsible party or parties legally responsible for maintenance, name, address, and telephone number to inspect and maintain the site and measures. The plan should transfer with ownership. The town recommends that a legal maintenance agreement be established, filed with the town clerk, and outlines the responsible party for maintenance, record of reports to be issued to town DPW and IW on a yearly basis. So that's was specifically outlined, and that's a DPW wording in other permits that we have issued. So.
Do commission members have any other suggestions for special conditions?
I just have a question. I have a suggestion. I have a question. I'm going to start with the question. That's Beth Sanford for the record. So in 7C, in terms of the legal maintenance agreement to be established, do we want to be specific about what would be entailed there? So in terms of maintaining the filters in the water management system and the dictate that a certain amount of salt was going to be used as proposed by the applicant.
Typically, Mr. DeAndrea has a design for the system. The standards come in from them. We will review that draft maintenance agreement and comment on it then. So, but we can't propose it in the reverse.
Okay. Yeah. So we meaning you?
The town. It'd be the town engineer, and I would review it. The town attorney would be reviewing
Department
it as well.
of Public Works as well.
Mm-hmm.
How about in terms of monitoring the plan when they start taking down some of the trees? Do we have that captured here?
No, not necessarily. We don't have it captured.
Yeah, I was wondering about whether we needed a save the trees plan.
Sure, you could add that. I feel like there's something, I mean, the plan is pretty specific.
Mm-hmm. What do other people think? Whether we, perhaps that's, is that not necessary?
I think if we're monitoring twice a month, and there's coordination between the developers, I think that might be an extra,
Yeah, I think right now, based on having gone to the site multiple times now over multiple years, I feel pretty familiar with the trees at this point myself. They typically, the arborist will tag all trees to be coming down. If you wanted to do something like that, but I don't know that I'd rather do it visually rather than a plan. So like you could say prior to removal, the contractor shall tag trees for removal to be reviewed with.
And advise us of it that's
We can come out and
Yeah.
verify. I mean, that's the only way I can think to do it.
I was thinking also in terms of trying to make sure that during the construction phase, none of the trees that aren't tagged to come down are damaged in any way. Whether that's sufficiently covered in the plans that we've seen.
So they do have a limit of construction within their documents. So that was actually provided initially. And even with the addition of the fire road that was then added, it's a very streamlined scope of activity. So they are pinned into that, to those locations. So I do ask for limit of construction associated with this particular project. So
that's perhaps unnecessary then.
Again, the overseer of the site is going to hopefully not see some guy going rogue. I'm not going to take trees down unnecessarily. It's expensive.
Well, I was
I know
thinking
they
about
get damaged, yeah.
damaging them, with
These are highly professional individuals.
okay.
I'm
No
optimistic.
rogue backhoe
I have a
drivers, huh?
question on process. Is there a motion to approve or deny the application, and then there's a motion about the interveners?
Yes.
Okay.
Yep. And then we do need to discuss also what should go into the report to P&Z, whether it should be anything over and above the actual decision itself, which will say why we reached the decision that we did. So let's just go back to the moment about whether we want to ask to have all the trees tagged that are coming down.
I think that's beyond.
I think it's cautionary, but frankly, when I drive around this town and see all the trees that are getting taken out in properties, I'd rather be cautionary.
Right. So one person thinks it's unnecessary. Another commission member thinks that it's a good idea to be cautious here.
I think it's outside our purview. I mean, unless there are trees within the wetlands or the upland review area, then it's
Well, I was
not.
thinking the upland review area.
But beyond that, it's not.
Yeah.
It seems outside of our purview.
So how do you feel about tagging the trees in the upland review area?
I'd be on board with the upland review area.
I would be, I think perhaps in the upland review.
Wouldn't that be standard anyway, as Kathleen Director Hahn was just pointing out? Wouldn't they tag the trees before they're working through the driveway area?
They're on the plan, so they are identified on the plan.
Right. Which is why
So
I went
whether-
back and walked the site. again.
Whether or not the arborist would then go through and tag them.
We can vote on it. Yeah.
I have another question about maintenance. Do we capture kind of maintenance of the wetlands plantings? They're going to restore it and the removal of invasive over time, or could it go back to, its previous form in 5 years or 10 years?
I'd have to go back and look at Mr. Kenny's information, but he had a lot of that within his detail.
I think he had a 3-year plan.
Yeah, so I believe it I don't believe in putting a special condition in that's not already in the plans.
Okay.
So there was quite a bit already substantially in the plans.
So we
that
just,
covered that.
but we'll be monitoring that. Is that reflected in here that we would monitor the implementation of the 3-year wetlands restoration plan?
So this one sort of says it, upon completion of commercial and activities, the engineer and landscape architect shall certify that the roadway and mitigation plans have been properly implemented. So that's at the end of the 3 years for him, for his project, for his part of the project.
I mean, you know, there's going to be a best effort, but you know.
Kathleen, this is Dan. Are you going to be the point person on all of this? I mean, if you are, you're going to be pretty busy. I'm going to tell you, this is amazing.
It's a shared responsibility, Dan.
With who? Yeah.
The staff here at Town Hall, so we've got multiple people, but for the wetland portion of it, these are standard conditions or these are special conditions within the wetland permit. So yes, these will fall, you know, to me.
Right.
And the reporting, which then I will share with other staff here who need to see these particular entities. You know, for the pre-construction site meeting, I typically will have the town engineer. I think I may have listed everyone. Actually, I didn't list everyone, but I know I would bring in the town engineer. I'd probably bring in one of the planning people. And so, yeah, so it's a shared responsibility. Don't worry.
Beth Sand for the record again, just going back to the wetlands landscaping plan. So between number 3 and 4 here, 3 says that there's going to be oversight. Let's just look at the landscape part by the landscape architect of all planning activities until completion. And then we're going to have a report at the end of the project, which is 3 years on terms of the planting. Should we put some midpoint to make sure that it's on track? That seems like a long time for it to go without some report to us.
If you wanted, you know, first planting season, second plant, you know, you can certainly increase it if you wanted to have additional reporting. You know, there's guarantees with all of this type of planting. The person who will be providing the plants has a contract with the developer that says something fails, I have to replace it. So there's a lot of built-in safeguards already.
Okay.
This
A lot of that's going away right now because of the 1,000-year storm and a drought and all that. I'm just telling you, dealing with landscapers, that things used to be guaranteed for a year. That doesn't exist with anyone I've spoken to recently. Recently this morning.
Oh, so I would be on board with some kind of interval reporting on the landscaping, maybe after or after it. I mean, if you plant in the spring and it's dead by the fall, and you know it didn't take, you know, so maybe on an annual basis between the first from 0 to 3.
Okay.
So three times.
Yeah, that's what I would say.
Yeah,
I think that's reasonable.
I was also wondering about inclusion as a special condition that the homeowners association bylaws include maintenance of the wetlands in the common area, and also that the areas proximate to the driveway, which are wetlands, are cared for so that those areas of wetlands do not deteriorate. You know, we got the sort of the first 3 years covered when construction and restoration of wetlands and plantings occur, but it's going to be important too that the homeowners association takes its responsibilities for those wetlands seriously. Is that something that we could put into a special condition?
And the homeowners association is done before they sell the properties.
Okay.
I don't know. I mean, so is when they go to sell the properties, it's like a private road where they already have an association and you're buying into it? I don't know.
We will see the details of that when the attorneys formulate. I don't know that we can, our just want to say the wetland permits have a life. So I think what
Yeah.
you might be talking about is in perpetuity.
Yeah,
And that would-
yeah.
I don't know that that is a suitable special condition because this comes to an end at a certain point.
Is this something that we could encourage P and Z? Oh,
that's a good suggestion.
encourage P and Z to take care of.
Yeah, possibly that.
But
might be a
let's
good
ask
suggestion.
Attorney Gelderman for his opinion on whether we could put something in about the homeowners association being obligated in perpetuity to maintain those wetlands that are in the common area.
That's a tough condition, simply because if the, I mean, first of all, typically a maintenance obligations are secured by a bond for a limited period of time. And again, I think that might be something, as you said, Angela, that might be appropriate in your report to the Planning and Zoning Commission as part of this, your review under the subdivision, to suggest something to the Planning and Zoning Commission. And it might be more appropriate for them to take a look at that as a condition of the subdivision.
Yeah, I think it's a pretty dicey area because you really don't want them to maintain, you don't want them to do anything to the wetlands.
Right.
I mean,
At a
and
certain point, I think Mr. Kenny was indicating that wetlands will do its own thing.
right, I mean,
Should-
unless there's phragmites that you need to remove, and I don't think we can.
Well, I suppose
Dictate that,
maintain
but-
then isn't the right word.
Yeah, I mean, you don't.
It's the
Not disrupt.
homeowners.
Does not harm
homeowners
it.
Association will take every
Yeah.
step possible to avoid degrading in
Well-
any
well,
way
that-
the wetlands.
There won't be yard waste and all of that kind of things that's already damaged the property wetlands.
Yeah.
Now that's part of the issue they've had over decades. So I think, yeah. So if there's some stipulation about being careful, but that's really what they're supposed to do anyway.
Right.
That's what our job is, to regulate that.
And Angela, I don't have a copy of the map, but I'm assuming most of the wetlands are going to be located on individual lots as opposed to common property. The driveway may be common. You know, when you have an association, that's because there's some common property that's owned, you know, in common by all the property owners. But if a wetland is located on someone's private property, then it's really not an association obligation. It's an obligation. And the obligation is to not do anything that will have an adverse impact.
Right.
So,
Right, but I believe that the wetlands that are just to the east of the shared driveway are going to be owned by the homeowners association. I mean, there's a sort of narrow strip of land that's on the property. I'm just trying to find the right map here.
well, I think it might be appropriate to say that if there's any activity within the wetlands that are in common, that are owned in common, you know, that any activity has to come back to the commission, just like any activity on the individual lots will have to come back to the commission.
Okay, I suppose what I'm trying to prevent is that where you've got, you know, collective ownership of a piece of land, that it may end up being degraded because nobody has a specific interest in it. And to the extent that that is wetlands, that would be unfortunate.
There's a lot of,
I think.
I'm just looking at slide 7 from, I think, last month's presentation. There's a lot of wetlands that are not part of.
Oh, that's not the wetlands I was thinking about. It's the
whole stretch
wetland
along the drive.
down
to
here.
to the east.
But you regulate activities within the wetland or the upland review area, as opposed to maintenance is a different thing. Typically, wetlands aren't maintained necessarily. You might have a rain garden, you know, that's done in mitigation that you would ask to be maintained, but your job is to make sure that there's no activity that's regulated that occurs within a wetland or an upland review area.
Well, I think choice of the word maintenance was a problem So it's really to try and ensure that there are no activities that would degrade those wetlands that are.
Well, by definition, those would have to come before you anyway. If there's an activity that would have
Right,
an
I'm
impact.
just worried that the homeowners association won't remember.
Will we be looking at, I mean, right now we're talking about approving or not approving the road and the
Yeah.
utilities.
Mhm.
The homeowners association, you know, more planning and zoning, we can, I believe, make some recommendations or suggestions, but every property is going to have to come to us for development. So we'll have a second shot at talking to individual developers, right?
Yes, but I think this particular piece of the wetlands that I'm referring to, we were told it was going to be owned by the homeowners association. Of course, now I can't find the map to look at. But I mean, it doesn't sound like there's a consensus in favor of trying to put anything in that would bind the homeowners association. So I'm happy to let it go. What about tagging the trees? Should we just take a straw vote on poll on whether we're in favor of making that part of a special condition, that all the trees that are going to be taken down should be tagged by the arborist?
In the upland review.
In the upland review area, yes. So all those who think that would be a good idea to include that, please raise your hand.
Not
1,
against
2. I'm sorry?
Not against.
You're not against it. Okay, and then I'm in favor of it too.
I mean,
I'm in favor of it.
you know,
Okay, so that was a straw poll, but a useful mechanism, I think.
Can I just read that out so that it
Yes.
makes sense? The applicant shall cause trees to be removed, shall tag those trees to be removed, and prior to removal, notify town staff.
Sounds good to me.
does that make 8 special conditions?
Yeah, you're done. 8. Mhm.
Okay.
The only trees that should be considered for removal need to be essential to the construction of the driveway. Is that not giving them free rein? Okay.
In the plan.
It's the dry hydrant that we're losing though.
Yeah, that's probably
Trees.
the most, I think.
Okay, so are we moving towards the point where we could actually consider a motion on the application itself of whether to approve or deny? And if we approve, subject to special conditions. Would anybody like to make a motion?
I'll make a motion, Commissioner Redden, for the record, to approve application IW 24-43 with the 8 special conditions listed by Director Holland and discussed.
Thank you. Somebody like to second that?
Commissioner Ramirez seconds the motion.
Very good. All those in favor, please raise your hands. Aye.
Aye.
So that is unanimous. Thank you, Dan. Okay, so now we need to move on to consider the pleading of the interveners that asserts that the proposed activity involves conduct which has or which is reasonably likely to have the effect of unreasonably polluting, impairing, or destroying the public trust in the air, water, or other natural resources of the state. And as we established at the beginning of tonight's meeting, the decision we come to here should be consistent with the decision we reached on to approve the application. So how are folks thinking about this particular second determination?
I'm ready to make a motion.
Well, let's talk about it first, huh? Does anybody see that, believe that the interveners have successfully asserted here?
I would, Commissioner Williams, I would say I don't think they were successful in doing that. And that Attorney Gelderman pointed out that future activity that is unidentified is not under our purview.
Very good. Anybody else like to add to the discussion? So I think we are ready for a motion to be made, Commissioner Redden. Thank you.
I'll make a motion on the notice of intervention and that the commission finds the interveners have not proven the applicant's proposed activities are reasonably likely to have the effect of unreasonably polluting, impairing, or destroying the public trust in the air, the water, or other natural resources of the state. Specifically, that the commission finds that the interveners have not set forth significant, credible, and quantifiable evidence to prove the allegations set forth in their petition.
Commissioner Ramirez seconds the motion.
Thank you. All those in favor of the motion, please raise your hand, say aye.
Aye.
That is carried unanimously. Then the last issue that we need to think about is what if we want, if anything, to put in the report to P&Z over and above the decision itself to provide the permit. Does anybody have any thoughts on that, including Director Holland?
I've been thinking about this for a while, actually, knowing you would get to this point at this point. You're at the point of trying to now think ahead perhaps and make any, it's your, as part of this process, this commission has the right to provide any additional comments that they see fit that Planning and Zoning Commission can potentially take into consideration as they deliberate the actual subdivision. As this particular subdivision came together and the iterations that it has gone through, I feel it's been pretty well developed from a wetlands perspective. As some of you said, above and beyond what sometimes we see on applications that come before us. I am not coming up with anything that you as a commission could provide additionally to planning and zoning as they look at it from a subdivision point of view, because the applicant has already provided so much in the way of protection of the wetlands and restoration of the wetlands on the lots on the site in general. I don't have any particular recommendation. I mean, maybe someone else is thinking differently on what, and Phil has some planning and zoning experience, so maybe he I don't know if he has subdivision experience, or maybe not, but don't want to put Phil on the spot, but.
Kathleen, this is Dan. Have you talked to Sarah about what they might want? I know it's not, probably it's too late for that, but she may give you some ideas what we could provide for them and make their job easier.
So staff-wise, we have had, multiple conversations internally as this has developed over the last year. So it definitely has been ongoing conversations between the staff regarding the application as a whole and sort of the process and what might be happening next. Nothing came up to the surface that the town planner would have made a recommendation. It's really this commission's job to make the recommendation to planning and zoning. If you see something that with perhaps one of the lots that you want to point out to planning and zoning as they consider actually putting lines on a piece of paper. So that's really what you're looking at.
I could think of, or I could come up with a scenario where we might want to say something to P&Z if, for example, a lot in a subdivision plan was 95% wetlands, and you really couldn't think that there would be room to actually put a property on. I mean, it seems unlikely that any developer would try to put that in an application, but that's a situation where I could see us putting something additionally in the report to P&Z. But we're not in that situation here.
Not yet.
No, and I mean, to the extent that there will be development on the individual lots, the property owner has to come to us for each individual lot. If there is proposed development in the upland review area.
And just to add to that a little bit, on each individual lot, feasibility studies have already been conducted as they put on the record for you regarding septics and potential stormwater systems. So they're not fictitious. So there is some data that potentially proves out those are developable lots. So there's nothing with 95% wetlands. So to your point, yes, that would be certainly something you would pass on to P&Z. Hey, lot number 1 looks 95% wetlands, reconsider that one. But I don't see that here. On this.
Okay, so I'm sorry, Commissioner Sanford.
I'm just looking at the, one of the, that was the alternative, but.
Oh, that's right.
Oh, I was just thinking in terms of maintenance, it looks like most of these houses have pools. And I think one thing we should stipulate is how they drain the water in the pools.
So that would come later.
Yeah.
Because right now that's not actually a proposal. It's
Right. We're not evaluating the lots. So when we evaluate them, because it happens on land trust properties.
Keep that in the back of your.
Yeah. Okay, well.
So just to summarize, it doesn't sound like there is anything that we would like to add in the report to P&Z. Basically our decision and the reasons for it are, I think what P&Z needs to see. We don't need to do a motion on that, do we, Director Holland? Attorney Gelderman, do we need to have a motion on whether we want to, and a vote on whether we want to add anything to the report to P&Z?
No, you can simply make a finding. I mean, you could vote on it if you chose to, but you can simply make a finding that your resolution is speaks for itself, and it's all you chose to submit to the commission, to the Planning and Zoning Commission. If there's nothing else that you wish to submit, I think that's enough. I think you can take a vote that's all you're submitting.
Okay, so who makes the finding?
Who makes the finding? You just somebody makes a motion that the only thing submitted to the Planning and Zoning Commission will be your resolution of approval.
Okay, well, I will make a motion that the only thing that will be submitted to P&Z is our determination.
I'll second the motion.
Thank you. All those in favor? Aye.
Aye.
That's carried unanimously. Thank you.
Okay.
So I think we can now move on to other items on the agenda. Agent report, administrative actions. And actually, I must say, I'm particularly interested in hearing about item 9, which, as we learned this evening, is a subdivision of a.
It's not a subdivision.
Oh, sorry.
Yeah.
Why don't you tell us about it?
So it was a busy month in addition to Brookwood. Number 9 is a subdivision, what they were referring to from 2017.
Yeah.
So basically development of a piece of land. So 277 Greenlee Road is new construction. All of the activities are in the upland review area. So that was an administrative review and approval. Goes through all the same bells and whistles that these folks go through: town engineer, town planner, so on and so forth. 894 Silver, and sometimes I have to.
So interesting that it's only that the inland wetland permit only came up almost 8 years after the subdivision was approved.
Those lots have been sitting. There's a lot of lots sitting.
I hadn't sold the property.
Yeah, it was just last year. I was a little surprised that she said it was 8 years, but it must have been idle for 8 years.
So
and the roadway development came to you guys. So you guys,
Mm.
some of you aren't on the commission then, but yeah, it was a minor, road coming in. We have multiple lots around town that have not been developed.
Mm.
They're just waiting. Yep. So do you want me to read all of these? But those were all the those were all the other administrative permits.
Right. Unless there was anything.
I try to
particularly
give very
interesting.
lengthy descriptions so you guys can see what I'm up to.
Yep.
So, and most of these are underway. So it is a very busy time right now. We're in the field as much as I'm in the office. So, good.
Are we allowed to tag along with you at times?
Inappropriate
for commissioners to come along and see the difference?
When you have a pending wetland application, you can come out with me. But once it's closed, I'm pretty much taking over at that point.
Yeah.
So,
I mean, prior to.
yeah. Okay.
Very.
And did you want to do number 15?
No, I think we decided we would
We're
wait
gonna table it 'cause
until
it's
May.
almost 10. That sounds good. to me.
Yep.
Okay.
So I think we could entertain a motion to adjourn. Somebody like to make it?
I will make the motion to adjourn the meeting.
I will second it. All those in favor?
Aye.
Good night, Dan. Thanks for hanging in there.
Yep. Thank
Good night. We'll see you in May, okay? I'll be home in May.